Peter, I tell a lot of my buyers, and my sellers, who's the benefit in the as-is contract?
Generally the buyer.
Super excited to have Peter Huy here in the studio with us, our legal eagle from Huy Jacob P.A. Today, Peter, I really want to talk about contract selection. I'm a buyer. I'm going into this contract. In layman's terms, we have two contracts in the state of Florida, and we have two flavors of those contracts. So tell me a little bit about what's important to me. What should I look at? What should I think about as it relates to deposits, as it relates to inspections, those kind of things?
Okay. The two flavors of whether you're in
A Naples contract or the rest of this Florida.
Whether it's a Naples or a far bar contract,
Yeah.
you're talking as is versus basically a standard contract.
Right.
So your as is contract is going to contain a due diligence clause. What that means is that if you do your inspections, your due diligence, you find something, your options are either terminate the contract or proceed with those defects. Now, as a practical matter, that doesn't always happen that way. There's some negotiation that occurs during the due diligence period, and you can negotiate out, if there is some type of inspection issue. However, it's not part of the contract.
Yeah.
Now, in a standard contract, you flip-flop a little bit. The standard type of contract is there to keep a buyer, more into the contract, meaning there will be inspections. However, if things are identified in the inspections, certain things, they got to be defective items, not, there's a gash on the wall or a gash in the baseboard.
Yeah.
These are like the HVAC's not working. And if those things are identified, the seller has the opportunity, but not the requirement, to fix those things. Now, if they don't fix them, you as the buyer then get the opportunity to terminate the contract, or just as with the as-is contract, proceed with those defects, depending on how, what you want to do or your comfort level with whatever is identified.
It's funny because to hear you say that, I kind of use the bowling analogy. You know how they have those bumper things on the lane, on the alley bumpers?
Yep.
And I think of the standard contract as having the bumpers on the alley, that there's rules in there and we're going to get to the back of the alley, no problem. Versus an as-is. Peter, I tell a lot of my buyers, and my sellers, who's the benefit in the as-is contract?
Generally the buyer.
Yeah.
Because the buyer, in pretty much their sole discretion, if the property is not suitable to them, they can walk.
Right.
Now let's talk about deposits for a second, because this is
Let's
kind of I'll call it a scary topic. Particularly when where the far bar is concerned. So deposits under the NABOR, the deposit, it's defined as made. So if your deposit ever becomes a risk, it's only going to be the deposits that you actually made. Under the far bar, however, it's all the deposits listed, which means even if you hadn't made that second large deposit, that is still at risk, even though you hadn't made it. So that's another major difference between the far bar and the NABOR. The financing contingency, another huge difference, which even my office has to be very, very careful on, and all realtors have to be, because on one, the finance contingency is automatically waived. That would be the far bar. On the NABOR, however, you have to waive it in writing. Now, if the date for the financing contingency passes, that allows the seller some rights, namely the right to terminate under the NABOR. But at least you as a buyer don't unwittingly lose your financing contingency just because nobody was paying attention.
Right, which is really a problem. Now, you kind of weaved in, once I sign a contract and I'm the seller, can I get out for any reason?
No, generally no.
Yeah. So I've had a few calls in this last week that sellers have said, well, I'm under contract, but I can get out. I don't like this or that. And I'm like, whoa. I'm not an attorney. Please seek an attorney's guidance, because that would be breaking the contract and therefore could have issues.
Right. And we've seen that occur, particularly where, let's say, a potential seller maybe is having second thoughts about the home. We're seeing a decent boom, particularly here on Marco Island, because people that have purchased decades ago, their homes are worth a lot more.
Yeah.
But I think a lot of people and sellers, they don't appreciate, I guess, the nostalgic value of their home. And so we do sometimes see that, particularly more often than not. Most of the time, though, after the sellers had a conversation with their attorney, they get back into the contract. They realize that this is a serious situation, and literally a buyer could force a seller to sell. Now, it's never as simple as that. It would require a lawsuit, a decent amount of time, but it's serious business.
Time and money. The other thing, Peter, you and I have walked through are deposits. Seller thinks, hey, I have these deposits, and they automatically go to me if the buyer defaults.
So let's talk about that for a second. So if I'm going to be the one holding your deposit if I'm the closing agent, right? And we're holding it, in a trust account, but we're acting as escrow agent, and I'm usually also representing the buyer. If, let's say the buyer does default, okay? Let's just say it's black and white default. The buyer still can say, no, don't release that deposit. And, very few things are black and white, but if they've got any type of leg to stand on, they can literally say, do not release that deposit. And under that contract, me as escrow agent, I've got contractual provisions in that contract too. One of which is that I do not release the deposit unless I have joint instructions of the party or by court order. Now, in that situation, obviously, I'm not getting joint instructions by the party. So now I'm left with a court order. That requires a lawsuit. And yes, if the seller, is most likely going to win and that deposit is most likely going to be forfeited, sure. But when? A year and a half down the road? How much in attorney's fees? $60,000 in attorney's fees to run an entire lawsuit to a trial? Maybe you win on summary judgment, depending on how clear the issue is.
Right.
But it's not in a vacuum. Theoretically, and you'll often hear, oh, well, they defaulted, therefore I'm entitled to the deposit.
Right.
Sure. But there's a lot more going on between the default and the time that you the date that you actually retain or tendered the deposit.
There's no way, Peter, that we can go through all of this today or at any time in a short amount of time. But what I do want you to know is, listen, this is why you hire professionals. You want to make sure your realtor is a professional that understands the contracts, that has done enough transactions to understand the contracts and the benefits of that. And then you want to get a closing company like Peter that really understands what has to go into this, because God forbid things blow up and there's an issue. Who do you want to call? Who do you want on your side? Not Ghostbusters. You want a great attorney and a great realtor. Look forward to talking to you again.